This week, we will be discussing concurrent ownership. Concurrent ownership, to understand concurrent ownership, you need to understand that when you have concurrent ownership, each co-tenant has the right to use and possess the entire property. So even if each co-tenant, there's two co-tenants, and each co-tenant has a 50% interest in the property, they still have the right to use and possess the entire property. Because each co-tenant has the right to use and possess the entire property, this can result in disagreements about what to use the property for, whether to lease the property, whether to build on the property, whether to live on the property. And how these disagreements, how the law treats these disagreements are going to differ based on the type of concurrent estate that the ownership is. Typically, when we say that there are concurrent estates, we say that there are three types of concurrent estates. And we focus on tenancy in common, joint tenancy, and tenancy by entirety. But I do want to highlight that there is another way to hold property, and that is in community property, as community property. The first two types of concurrent estates that are in purple, the tenancy in common and the joint tenancy, these are tenancies that can exist regardless of marital status. With the tenancy by entirety and community property, the parties need to be married or have a common law marriage. All right, so what is a tenancy in common? With the tenancy in common, each tenant has an undivided fractional interest in the property. And that fraction, the amount of that fraction can differ. It just depends on the conveyance. So they have an undivided interest in the property. And you'll know that you have a tenancy in common because the conveyance will read to A and B as tenants in common. Tenancy in common has been considered the default conveyance when it's a concurrent conveyance in modern law. So modern law considers tenancy in common to be the default if it is unclear from the conveyance what the intent of the transferor was. Now, in common law, it was actually joint tenancy that was the default. You know you have a joint tenancy because it's 2A and B as joint tenants with the right of survivorship. And the key difference between a joint tenancy and a tenancy in common is that each joint tenant has the right of survivorship. So for both a tenancy in common and a joint tenancy, each tenant can use and possess the whole property. But when you have a joint tenancy, the joint tenant has a right of survivorship, meaning that if A and B have joint tenants with right of survivorship, then if A dies, A's interest in the property goes to B automatically, regardless of what will they have, etc. So B automatically becomes the sole owner of the property on A's death. So another way to think about it is with a tenancy in common, A and B would have a freely alienable, divisible, descendable interest So they could devise their interest, they could sell their interest. With a joint tenancy, there it is alienable because the joint tenant can sell their interests, but they don't have the ability to devise the property, and it's not descendable, so they can't will it to somebody else, or if they were going intestate, it wouldn't go to somebody else after they died because it always goes to the other co-tenant upon death. So that's what the right of survivorship means. A little bit more about joint tenancy. The common law required 4 unities to be present to create a joint tenancy. The first is time. So all the joint tenants have to acquire the interest at the same time. No exceptions. It all has to be, the interests have to have been obtained on the same day at the same time. The second unity is title. Title requires that all co-tenants acquire the title to the property by the same instrument. So the same instrument must convey the title or the interest to both A and B if A and B are joint tenants. The third unity is interest. So with a joint tenancy, the joint tenants have to have the same shares in the estate. They're going to be equal in size and duration. So if you remember when we were talking about tenants in common, we said that they could have different percentages of ownership, right? We said A could have 2/3 interest, for example, B could have a 1/3 interest. But that's not the case with joint tenancy. There has to be unity of interest. So they both would have to have 50% of the property. They must also have an equal right to possess, use, and enjoy the whole property. So there can't be any limitations on possession. So if you don't have any one of these 4 unities, then you have tenants in common. But if you have these 4 unities, you have joint tenancy, and then you'd have the right of survivorship. Now, if one joint, remember we said that joint tenants can sell or transfer their property to somebody else. But if they do, then the joint tenancy is going to be severed. If it is severed, then they become tenants in common. If you think about it, it makes sense. If a joint tenant sells their share of the property, then you have broken the unity, right? Because another person is coming into possession of that property, but it's at a different time, it's in a different title, and so the unity has been broken. And so we say that the joint tenancy has been severed. And if it has been severed, then we have a tenancy in common. So again, the key difference between a tenancy in common and the joint tenancy is that, one, to have a joint tenancy, you need to have the 4 unities. 2, if you have a joint tenancy, then you'd have a right of survivorship, whereas you don't have that with a tenancy in common. 3, there has to be equal possession of to have a joint tenancy. So if you have different fractional interests, you automatically know you have a tenancy in common. What about a tenancy by entirety? Well, to have a tenancy by entirety, you have to be a married couple. And just like a joint tenancy with the tenancy by entirety, each tenant would have an undivided right to use the property. And there is a right of survivorship. But while a joint tenancy can be severed unilaterally, meaning one joint tenant can decide they want to transfer the property, thereby severing the joint tenancy, with a tenancy by entirety, it can only be ended by death, divorce, or agreement by the two spouses. So one spouse cannot unilaterally or even secretly transfer the property to another. They can't sever this interest. Neither spouse can, I forgot to put these up. So only married couples can hold a tenancy in property. And you can think of it like a joint tenancy, but with a fifth unity of marriage. Another difference from a tenancy by entirety and a joint tenancy is that neither spouse can encumber his interest in a joint tenancy. What does that mean? Well, if you, for example, own property with a house on it in tenancy by entirety, if one spouse wants to go take out a loan, a secured loan on the property, they have to get the permission. They have to get the permission of the other co-tenant. That necessarily, and if that person, that co-tenant that goes, and if they encumber the property, if they get that loan on the property without the consent of the other co-tenant, then the creditor cannot collect, right? So this offers creditor protection for married couples. It also means that if one spouse, let's say the husband, were to incur debt or were to have a judgment against them for a lawsuit, and it is only supposed to encumber his separate property, it would not encumber his half of the tenancy by entirety. So in other words, they cannot go after his half of the property when they're trying to collect money for that judgment. They can go after all of his other separate property, but if it's in tenancy by entirety, then it is protected for the most part. That would not be the case with the joint tenancy. If there's a joint tenancy and somebody has a debt that needs to be collected, then the 50%, the creditor can go after 50% of the property and can sever the joint tenancy. So there are some benefits to having a tenancy by entirety. So for all of these different types of concurrent ownerships, I showed you the typical language that's used to communicate each of them, right? So we said tenancy in common, it would be to A and B as tenants in common. For joint tenancy, we said to A and B as joint tenants with right of survivorship. And tenancy by entirety, the language was to A and B as husband and wife as tenants by entirety. It was in a previous slide. And so in order to avoid ambiguity, attorneys usually use these precise phrases. But there are cases in which the grantor or the transferor, they don't use this precise language. And if there is ambiguity, courts really have three different ways that they can rule. As I said before, at the common law, they favored joint tenancy. So if it was unclear or ambiguous to what, based on the face of the document, as to what type of concurrent ownership it was, the common law would default to a joint tenancy. Now, current law or modern law, the grantor, the assumption by the court, if there is an ambiguity, is that there's a tenancy in common. So the default now is tenancy in common. Now you're starting to see a minority of courts take a third approach. You think of it as an up-and-coming approach or a modern trend, and that is actually to look more at the grantor's intent. So rather than just look at the face of the document and if it's ambiguous, go to one of the defaults, they look at the document and perhaps some extrinsic evidence to try to look and see what the grantor's intent was in the conveyance. Did they intend to convey a tenancy in common, a joint tenancy? So they have three different ways that they can resolve, courts can resolve this. All right, one more concept, it actually relates to joint tenancy, and just wanted to go over it very quickly. You can read a short paragraph on it on page 383 if it doesn't make sense to you. But let's say it's called the use of a straw person. Yes, like a straw man, a straw person. So suppose that we have an owner A who owns Greenacre, and they want to create a joint tenancy with their sister B. Can A just create a deed that says that to A and B as joint tenants with right of survivorship? And at common law, the answer would be no, because remember, you have to have the four unities, and technically A already had an interest in the property before. And so the common law would not consider that to be a valid conveyance. Or it would default to tenancy in common, right? So a technique developed called the use of a straw person. And to avoid this technicality, A could convey Greenacre to C, and then C would convey the land to A and B as joint tenants with right of survivorship. So it involved conveying it to C, who was just going to turn around and convey it as joint tenants. And if you use that technique, you had the four unity that you needed. Nowadays, a lot of jurisdictions have eliminated the need for the straw person, and the grantor can create a joint tenancy just by conveying it in a deed to somebody else with him and her as joint tenants. All right, co-tenancy lawsuits. So I just wanted to quickly go over the types of actions that can be brought when you have a co-tenancy, so you have some context when you're reading through the cases. So when you have co-tenancy lawsuits, you could have a contribution action, an accounting action, or a partition action. A contribution action is a lawsuit to obtain reimbursements for expenses that have been paid. Kind of is in the title, right? So the plaintiff is trying to obtain some contributions to be reimbursed for the expenses that they paid. An accounting action is a lawsuit in which the plaintiff is trying to get an accounting of what money the property has made. And so you can think of an accounting action as one that is to seek a split of rents, profits, or any other proceeds. So the plaintiff is going to the court and saying, my co-tenant has not split the profits from the property with me. I want an accounting to see what profits they've gotten so we could split it even. Okay. The third type of action is called a partition action. A partition action partitions or splits the property and then settles the financial affair of cotenancy. So it is used when co-tenants can't agree, and because they can't agree, they just decide they are going to split the property and settle the financial affairs of the cotenancy. All right, let's do a hypo. Let's say that S conveys Green Acre to A, B, and C as tenants in common. Shortly after, A sells his interest to F. Then B dies, devising her interest to G. Who owns what interests in Green Acre? The answer is that F, G, and C own Green Acre as tenants in common. Let's take a look at why. So because it's a tenancy in common, A, B, and C have the right to transfer their interests or devise their interest. The interest is also descendable. So A transfers his interest to F, then B dies, devises her interest to G. So F and G take on A and B's interests, and C keeps their interest. So F, G, and C own their interest as tenants in common. So suppose instead that the grant read A, B, and C as joint tenants with the right of survivorship. Would the result change? So your answer should change. And the reason is because as soon as A transfers their interest to F, then they have broken one of the four unities, because F takes on the property at that point as a tenancy in common with B and C. But B and C at that point still are joint tenants with right of survivorship, because their joint tenancy has not changed. Then B can't devise the property to G. C would take on B's property interest when B dies. And so the answer would be F and C. They would have interest as tenants in common. I know it's a little bit complicated, so you might want to try drawing it out. Remember, A is transferring to F in a sale. That sale is going to break one of the unities. As such, when F takes on the property, he does so as a tenant in common with B and C. But B and C still have a joint tenancy with each other with the right of survivorship. And so B cannot devise, remember, because with a joint tenancy with right of survivorship, you cannot devise your property. When you die, it goes to the other joint tenant. So when B dies, C takes on B's interest. So F and C then, what is left, because they didn't take at the same time, right? F took later. So they have a joint tenancy in common with each other, F and C. So again, the answer is F and C as a tenancy in common. So we have said that a joint tenant can sever a joint tenancy with the transfer. But what about if a joint tenant leases their interest? They don't sell it, they don't permanently transfer it, but they lease their interest, or they mortgage their interest. Does that act sever the joint tenancy? Well, that question is going to be answered in our next case, Tenhet v. Boswell. All right, in Tenant v. Boswell, the facts are as follows. Raymond Johnson and plaintiff Hazel Tenant, they owned a parcel of property as joint tenants. Purportedly, without the plaintiff's knowledge or consent, Johnson leased the property to the defendant. And the lease was supposed to be for a period of 10 years. But Johnson died 3 months after the lease was executed. So the plaintiff tried to establish her right to possess the property solely because, it was a joint tenancy. And she tried to evict or demand that the defendant Boswell leave the premises. And Boswell refused to. So the court here is trying to determine what rights tenant has and what rights the lessee has. So on page 385, the court goes through the rules for a joint tenancy. They talk about the 4 unities, and they say that if one unity is destroyed, then the joint tenancy is severed, and a tenancy in common results, just like we discussed. Also, one of the 2 joint tenants can unilaterally terminate the joint tenancy by conveying his interest to a third person. That means unilaterally means conveying it without the knowledge or consent of the other party. So those are the rules. Now, the court makes some considerations. They say that on the one hand, you could argue that a lease destroys the unities of interest and the unity of possession. Because by leasing the property to another, the joint tenant is transferring to the lessee his present interest. And he just retains a reversion. There's also the possibility that the lease could just continue beyond the lifetime of the joint tenant. Right? And so the court says, on the one hand, Johnson should have the freedom to alienate or transfer his interest. But on the other hand, tenant still has the right to complete ownership and possession upon his death. So they go over what the common law rule is, what other jurisdictions have done, and then what this court decides to do. The common law rule would view a lease by a joint tenant to a third party as a severance of the joint tenancy. So the common law would have said that this situation means that we have a severance. Then the court compares it to other jurisdictions, and they say that there is, these other jurisdictions would say that there would have only been a temporary severance that existed during the term of the lease. And when the lessor dies, then the existence of that lease would operate as a severance and extinguish the joint tenancy. So it depends on when, essentially, the lessor dies. So if the lease is in force, right? So if, let's do hypothetical to make more sense. Let's say A and B have a joint tenancy, and A decides to lease their interest in the property to Z. Okay, and so what these courts would say is that if A dies during the term of the lease, which we'll just say is 2 years. So if A dies within the 2 years of the lease, then the joint tenancy is severed. If, on the other hand, the term of the lease expires before the lessor dies, the joint tenancy is undisturbed. So if A were to live for 3 years and then the third year they were to die, then the courts would find that the joint tenancy was not severed. This court doesn't agree with either of these rules, and it came up with a third option, which is that you need to look at the express intent of the lessor. So it looks at the facts of the case, and it says that here the lessor did not appear to want to sever the joint tenancy, and because he didn't have the intent to sever it, he didn't demonstrate the intent to terminate the joint tenancy, then they should respect his wishes. So on the issue of whether or not the joint tenancy was severed, the court said it was not because they looked at the intent of the lessor and found that he did not want to transfer the property. The second issue the court deals with is whether or not the tenant takes the full property with encumbered by the lease or unencumbered by the lease. Can the lessee still stay in the property? Does tenant have to honor his lease? And the court says a lease is only valid insofar as the interest of the lessor in the joint property is concerned. It follows that the lease of a joint tenancy property also expires when the lessor dies. So what the court is saying is that a joint tenant can only transfer the interest that they actually have. And they don't have the ability to transfer any property rights after their death. So, as a result, the lease is not in effect after the death of the lessor. So the court says when a joint tenant dies, his interest dies with him, and any encumbrances by him on the property become unenforceable against the surviving joint tenants. Now, do you think this case is fair to unsuspecting lessees? Was the results equitable to the lessee? Should the lessee have to leave the property given that they didn't know that it was held in joint tenancy? Well, you could argue both ways on this one. I would perhaps argue that it is fair because Boswell could have protected his interests by searching Johnson's title before he entered into the lease. Now, I agree that it's not common for a lessee to search the title before agreeing to a lease, but I think that on the facts of the case, it is arguably fair, but there is strong arguments for it not being fair as well. So here I'm just looking for some effort. The next question I have is it fair to allow a co-tenant to sever a joint tenancy without telling the other co-tenant? Is it fair to allow a co-tenant to sever the joint tenancy without telling the other co-tenant? What do you think are the arguments for or against this right? So we talked about severing interests by transferring the property to another. But there are cases when the joint tenant doesn't want to transfer the property to another person, but they can't agree with their co-tenant on the use of the property or whatnot. So they can sue. Any tenant in common or a joint tenant has a right to sue for a partition or for actual division of the property interests. The question that often arises here is, how are they going to partition the property? Should they actually physically divide the property and give each person a percentage of the property? Or is it fairer to sell the property and divide the proceeds, right? So let's say you have a house on a piece of land that you own in tenancy in common with a cousin, and you can't agree on who should live in the house, or if the house should be rented out. So you file a suit for the land to be partitioned. Well, how do you decide who gets the house versus who gets the acre of farmland on the side? Can you equally divide up the house? Is it even feasible to divide up the house? Or is it better if the house is just sold? Well, what if that house has sentimental value and your grandmother lived in it? You both don't want the house to be sold. So it can be pretty difficult to decide when you have a partition issue as to whether or not it's going to be partitioned in kind or partitioned by sale. So next I want to go over what a co-tenant's rights and duties are. And the co-tenants can decide how the rights and duties are going to be divided. They can do that contractually, and if they do, then courts will respect what the contract says. But absent a contractual division, the co-tenant's rights and duties will default to what the default rules are. Now, the rights and duties of tenants, there are really four commonly discussed rights and duties. The first right is the right to occupancy. So both co-tenants have an equal right to occupy the property. So both tenants have an equal right to occupy the property. That's what the right of occupancy says. If they are ousted, which is that a co-tenant in possession refuses to allow the co-tenant to occupy the property, then they will be liable the pro rata share of the rental value of the property. But absent an ouster, a co-tenant in possession does not owe any rent to the other co-tenant. Just because a co-tenant refused to or did not want to live in a property doesn't mean that the co-tenant that lives in the property is required to pay rent to the other co-tenant. But like we said, if there is an ouster, right? If a co-tenant occupies the property and refuses to allow another co-tenant to occupy the property, then that other co-tenant is entitled to damages. So for example, let's say that A ousts B. A would be liable to B for B's pro rata share of the rental value. And let's say that rental value is $1,000 per month, and both A and B have equal shares. Then A would be liable to B for $500 a month. Now also note here that if B ousts A, I'm sorry, if A ousts B, okay, if A ousts B, A is effectively an adverse possessor. I'm going to repeat that. If A ousts B, then A is effectively an adverse possessor. So if B does not assert their interest within the statutory period for adverse possession, then A can take the entire property as an adverse possessor. All right. So we talked about the right to occupancy. We talked about ousting. The third right, I guess we can, or the second right we can talk about as far as co-tenants are concerned, are sharing rents and profits. So each co-tenant is entitled to a proportionate share of all the profits, the rents and profits that come from a land. So let's say that A and B own property as co-tenants, and on that property they have a farm, and they harvests apples and sells them and makes $1,000 a month doing so. Then A would owe B a prorata share of whatever A takes from the land. So out of the net profits, they owe a prorata share of the net profits for the apples. So what that means is that if there's $1,000 that A makes from selling apples and A and B own the property 50% each, then A would owe B $500. Well, let's do some hypothetical questions. Oh, wait, before we do hypothetical questions, so sorry. I forgot one more very important right/duty that co-tenants have, and that is to share costs. So the general rule is that each co-tenant must pay his or her proportionate share of the expenses. So they must share in the costs of the property. If a co-tenant does not pay their share of the expenses, the other co-tenant can seek reimbursement for the expenses that they occurred. Now, there's a little exception here. So a co-tenant can seek reimbursement for expenses from the other co-tenant, but in some jurisdictions, if one co-tenant lives in the property, they incur expenses. Let's say A lives in the property. They incur expenses because, the property, they need to repair the property. And B does not pay their share of the expenses. A can only go after B for the share of expenses minus a credit for what A would have paid in rent if A rented the house. So it's this weird exception we have here that we don't require a co-tenant to pay rent for living in a property to the other co-tenant. But if A lives in the property and the property, there are some costs associated with upkeep for the property, they can go after B for B's share of those costs, but only after giving B a credit for what the rent would be. All right. Now, there's a difference between repairs and expenses for upkeep versus improvements on the property. So while co-tenants are required to pay their part for upkeep, they are not required to pay for improvements. So when a co-tenant improves the property, they do it out of their own pocket, but they do receive a credit that is equal to whatever increase in the market value that occurred because of that improvement. Now, they only get that credit if there is an accounting for profits from the property or if there's a partition action. Here's what I mean. Let's say A has their apple farm, apple orchard, and they pick their apples and they make $1,000 a month in profits. And B brings an accounting action against A to tell them, hey, I want 50% of the apple sales. Let's say A had also built a back porch onto the house on the property, and that back porch increased the value of the property by $10,000. So A does not get to go to B and ask for $5,000 or B's share of the costs for the improvement. A has to pay that out of their own pocket. But now when B comes after A and says, hey, I want an accounting, I want to be paid the profits, A can say, I want a credit for that $10,000 improvement. All right, so let's go to the hypos. So here, what we're talking about is what expenses do co-tenants normally share? What expenses do co-tenants normally share? Hypo number 1. A is the sole occupying co-tenant, and they unilaterally, meaning on their own, build a greenhouse on red acre. A then demands contribution from the co-owner B. A has not ousted B. Does B need to pay? No, B does not need to pay because A improved on the property. So at this point, A is responsible for the costs solely. So A cannot bring this contribution action. A could only bring a contribution action for expenses that were to maintain the property. All right, so let's say the same facts as number 1. But instead of seeking contribution, A seeks to keep the additional profit the greenhouse brought from the sale of red acre. So does A receive all of the additional proceeds received because of this improvement? How would they calculate how much A receives? Well, A gets to keep some of the additional profit, right? They get to keep the profit from the greenhouse because they built this house. All right, so the greenhouse is the house that they built. So co-tenants don't have the obligation to contribute to any improvement on the property, but when one co-tenant makes the improvement, she can recover the value added to the property, not the amount expended, the value added. So in this case, since A built the house, the greenhouse, when they sell Red Acre, when they sell the land, A can get whatever amount that the greenhouse improved on the market value of Red Acre. So if the greenhouse improved Red Acre's market value by $20,000, then A gets that $20,000 because they're the ones that paid for the improvement. All right, Hypo 3. C and D each own an equal interest in Blue Acre as tenants in common. C then sells all the lumber and coal interests in the property for $200,000. Does D have any claim against C? Yes, D does have claims against C. D can bring an action for accounting and ask for $100,000 that were generated from selling the lumber and coal interests. That's it for co-tenant rights. We're going to talk about marital rights in a separate presentation.